All right, today we are tackling a massive concept, one that sits right at the heart of the UK's unwritten constitution, parliamentary sovereignty. For centuries, it's been seen as this bedrock idea, this unshakable pillar of British law. But is it really as solid as it seems?
So let's just boil it down to one core question. Can the UK Parliament really make any law it wants? I mean, any law at all? Answering that one question is going to take us on a pretty wild ride through one of the most powerful and, honestly, most debated legal ideas in the entire world.
Okay, so before we can talk about the cracks, we have to understand the original building. We need to look at the classic old-school view of parliamentary sovereignty. Think of it as this impenetrable fortress of state power.
At its most basic, parliamentary sovereignty just means that Parliament is the boss, period. Whatever law it passes is the highest law in the land. Its power to make law is, in theory, totally absolute.
And if you're going to talk about this, you have to talk about this guy, A.V. Dicey. He's the 19th century scholar who literally wrote the rulebook on it. His definition is the one everyone comes back to. Parliament has the right to make or unmake any law, whatever.
And Dicey broke this down into three simple but incredibly powerful ideas. First, Parliament can legislate on literally anything. Second, nobody, and that includes the courts, can question or overturn its laws. And third, and this is so important, no parliament can tie the hands of a future one. Every new parliament starts with a clean slate, with the exact same absolute power as the one before it.
Now, this idea didn't just pop out of nowhere. Its roots go way, way back. You can see the key moments here, but the big one is the Bill of Rights in 1689. This was a revolutionary moment that officially put Parliament's power above the king's, a huge power shift. So we get it, right? Absolute power. But what does that actually look like in practice? Let's take a look inside that fortress and see what the operating rules are. And that brings us right back to Dicey's third principle, which is just critical to the whole thing, the idea that this power is continuous, it can't be given away. So let's put it to the test. Could a parliament today pass a law that a parliament in 10 years is forbidden from changing?
Well, from a purely legal standpoint, the answer is a hard no. And that's because of two really powerful legal ideas. You've got express repeal, which is easy. A new law just says, hey, that old law, it's gone. But the more interesting one is implied repeal. If a new act clashes with an old one, the new one just wins, automatically. The most recent act of Parliament is always the king of the castle.
But, and this is where it gets really interesting, the courts have started to add a little twist to this. In a famous case called Thorburn, a judge, Lord Justice Laws, said, hang on, maybe not all laws are created equal. He suggested there are regular laws, and then there are constitutional statutes, these big foundational laws, like the ones that set up the Scottish Parliament. And for those, he argued, implied repeal isn't enough. Parliament has to be super clear and say out loud that it wants to change them. You can't just do it by accident. In this case, right here really shows you the pecking order. The royal prerogative, that's the collection of ancient powers held by the crown. But in the De Keizer's hotel case, the courts made it crystal clear. When Parliament passes a law, a statute, on a topic, that statute always wins. The law made by the people's elected representatives trumps ancient inherited power.
Okay, so for centuries, this fortress of sovereignty seemed pretty unshakable. But then the late 20th century rolled around, and some powerful new forces started to show up, and they began to seriously test the strength of those walls.
Challenge number 1, joining the European Community, which later became the EU. Now, the European Communities Act of 1972 was a British law, passed by Parliament. But what it did was pretty radical. It basically told our own courts that if there was a clash between UK law and EU law, they had to give EU law priority. It was a voluntary choice by Parliament to limit its own supremacy.
And this all came to a head in the massive Factortame case. The House of Lords did something that had never been done before. They effectively hit the pause button on an act of the UK Parliament because it clashed with EU law. This was a genuine earthquake in British law. It showed that while the UK was in the EU, it had agreed to play by a different set of rules.
The next big challenge was the Human Rights Act of 1998. This was huge because it basically brought the European Convention on Human Rights into UK law. For the first time, you could walk into a British court and argue that your human rights had been violated under that convention.
Now, the really clever thing about the Human Rights Act is how it was built specifically to keep parliamentary sovereignty intact. You see, in the US, the Supreme Court can just strike down a law and say, nope, that's unconstitutional, it's gone. UK courts can't do that. Instead, they can issue what's called a Declaration of Incompatibility. It's like a big, flashing red light for Parliament saying, hey, this law you made, it clashes with human rights. But, and this is the crucial bit, the law still stands. It's up to Parliament, not the courts, to decide whether to fix it.
And as Lord Stain said here, the Act was a masterclass in clever legal drafting. It set up this new conversation between the courts and Parliament about rights, but it never took away Parliament's final say. So, the fortress was modified, maybe a new window was installed, but the foundations were still solid.
So, after all that, after these huge challenges, where are we today? How strong is that fortress of sovereignty here in the 21st century?
This gets us to a really deep philosophical tension. The rule of law is the idea that everyone is under the law, right? No one is above it. But pure sovereignty says Parliament is above the law. It can make any law it likes. So what if it passed a law that was, truly awful? This actually came up in a case called Jackson, where some very senior judges basically mused out loud that if Parliament tried to do something outrageous, like abolish the courts, maybe the courts wouldn't have to accept it. They hinted that maybe the rule of law itself puts a limit on Parliament's power.
So when you put it all together, here's the modern picture. Yes, parliamentary sovereignty is still the ultimate legal rule, but Dicey's pure anything-goes version, it's just not politically realistic anymore. It now operates in this complex dance with the courts, with human rights, with international agreements, and yet you could argue that Brexit was the ultimate mic drop for the classic doctrine. It proved Dicey's third point perfectly. What one parliament joins, a future parliament can always leave.
Which leaves us with a final question to chew on. Is parliamentary sovereignty still that absolute legal power that Dicey described? A fortress standing proud and untouched? Or has it changed into something more flexible, a powerful political idea whose real strength shifts and changes with the times? Thanks for joining this explainer.